In this lecture, we're going to discuss heightened scrutiny, the intermediate test that the court uses and applies to things like classifications by government according to sex, according to age, and sexual orientation. So remember from the last lecture, we discussed this heightened scrutiny test, and we said that here government bears the burden, but the burden is much less than under a strict scrutiny or suspect classification kind of analysis. Strict scrutiny and suspect classification, they're interchangeable terms under equal protection. So under a heightened scrutiny analysis, government has to demonstrate, of course, so government bears the burden, so government has to demonstrate that its policy is substantially related to an important governmental objective. And we talked a little bit about what that means. Substantially related to an important governmental objective. Important is not just a legitimate governmental objective, it goes beyond the ordinary things that government does. So to impose some kind of age restriction or restriction according to sex or sexual orientation, the objective must go beyond something like, well, we want to keep the roads clear, or we want to maintain order. Well, those are things government ordinarily does. It can't discriminate on the basis of gender or sex in the maintaining of order in the ordinary way. For example, a curfew that required all males to be indoors by 8 p.m., but not females, probably would be analyzed under heightened scrutiny, and the court would say, well, your objective is to maintain order, but that's not an important governmental objective. That's a legitimate governmental objective. And this heightened scrutiny test is reserved for review of policies where government classifies according to age and gender or sex. So the first case we come to is Reed versus Reed, excerpted in your text. The Reeds had divorced, and they were divorced when their son committed suicide, and he died intestate, which means he did not have a will. He did have an estate, though, some possessions which needed to be distributed, and the court needed to appoint an administrator to administer the estate and dispense the possessions of the son. So they appointed the husband. There was a law actually in Idaho that required that where an individual died intestate and their parents were still living, the state would defer to the male and appoint that individual as the administrator over a female. Well, Mrs. Reed didn't like this very much, and so she challenged the law and asked whether it discriminated against women in violation of the Equal Protection Clause, and the court says yes. And the majority opinion in Reed is written by Chief Justice Berger. However, Berger doesn't announce a heightened scrutiny test. He actually uses rational basis and applies rational basis to the law and says that government hasn't met its standard. Here's what he says. While all laws discriminate, the court has long held that classifications cannot be arbitrary and must be reasonably related to the object of the legislation. That's a rational basis test right there. The court just stated a rational basis test. Here, Idaho's reasons for ranking men ahead of women in these disputes did not meet this standard. Well, Idaho said, well, we want to make certain that that there isn't a conflict within the family, and so automatically doing this will stop the conflict, right? It'll take the conflict between the family away. It's just boom, it's the male. Also, it's appropriate for the state to assume that the male in these circumstances has better education, a better knowledge of the legal system than the female. The court doesn't buy it. But in the very first case about sex discrimination, the court sides in favor of the women, right? Sides in favor of Mrs. Reed, but applies the lowest test, not the equal protection test. We had to wait until Craig versus Boren for the Supreme Court to announce a heightened scrutiny test. This case raised the question of whether an Oklahoma statute violated the Equal Protection Clause by establishing different drinking ages for men and women. So it established a higher legal drinking age for men than it did for women. And of course, this made some males pretty angry, and so they asked whether this was sex discrimination in violation of the Equal Protection Clause. The court says yes, it does violate the Equal Protection Clause, and the majority opinion's written by Brennan, and he here announces a heightened scrutiny test. Here's what he says: laws must serve important governmental objectives and must be substantially related to the achievement of those objectives. This is the heightened or mid-level scrutiny standard. And applying that standard, Justice Brennan says, nope, the state has not borne its burden to maintain order. It hasn't demonstrated that that is an important governmental objective beyond what it ordinarily does, and it hasn't shown that it's substantially related to achieving that objective, that by raising the minimum drinking age for men above that of women, it's somehow achieving its objectives more clearly. Now, that brings us to the last case, Romer versus Evans. Now, as we know from Lawrence versus Texas, the state cannot discriminate against homosexuals in private conduct, right? So they can't ban and punish homosexual conduct that occurs in the privacy of the home. And we know that that's part of the right to privacy, which is part of the meaning of due process in the 14th Amendment. Here, though, the court hears a challenge to a law under the Equal Protection Clause. So in this case, the people of the state of Colorado voted on a law that read like this. It wasn't a law, actually. I'm sorry. It was an amendment to the Colorado Constitution. This Amendment 2 read like this, and this is a little bit long. I'm sorry about this, but let's think this through. Neither the state of Colorado, through any of its branches or departments, so in other words, not the governor, not the legislature, or the courts, nor any of its agencies, political subdivisions, municipalities, or school districts, shall enact, adopt, or enforce any statute, regulation, ordinance, or policy whereby homosexual, lesbian, or bisexual orientation, conduct, practices, or relationships shall constitute or otherwise be the basis of or entitle any person or class of persons to have or claim any minority status, quota preferences, protected status, or claims of discrimination. This section of the Constitution shall be, in all respects, self-executing. Okay, so this amendment to Colorado's Constitution was challenged under the Equal Protection Clause, and the court was asked to determine whether this was a violation of the Equal Protection Clause because it deprived this class of individuals of the most basic rights, not simply granting of preferences, but also the ability to go to the Colorado court and say, I have been discriminated on the basis of my sexual orientation, even to make a legal claim before a court. And others joined in. The court says, in answer to the question, is this amendment permissible under the Equal Protection Clause? The court says no. Kennedy writes the majority opinion. He says that the law imposes a special disability on gays and lesbians and no one else. Now, let's be clear here. The state of Colorado was really attempting to ensure that people who discriminated against gays on the basis of religious orientation would be protected, right? I mean, that was clearly the purpose of it. I don't think that the people of the state of Colorado were attempting to specifically to target gays and to target them for discrimination. If you read the amendment, what the people of the state of Colorado were really doing was attempting to ensure that no one could be sued by a gay person for discrimination, and that gay people could not claim special preferences or quotas. Uh, and apparently some municipalities and school districts had put some preferences and quotas into place. And so the court overturns this amendment and says that Amendment 2 not only fails, but also actually defies and confounds normal equal protection analysis. Kennedy says it's both too narrow and too broad to meet constitutional scrutiny. It identifies persons by a single trait and then denies them protections across the board. The resulting disqualification of a class of persons from the right to seek specific protection from the law is unprecedented in our jurisprudence. It is not within our constitutional tradition to enact laws of this sort. Central both to the idea of the rule of law and to our own constitutional guarantee of equal protection is the principle that government and each of its parts remains open on impartial terms to all who seek its assistance. So by denying even a cause of action to homosexuals, the law spanned too broadly. Before we go to on to San Antonio, I want to mention that Justice Scalia again dissents, and here he says, the court has mistaken a culture comf for a fit of spite. In other words, Justice Kennedy has said that the Amendment 2 demonstrates animus toward gays. And okay, certainly that may be true. I also think that really the state is moving to protect people who want to discriminate against gays from disability, from punishment, and also from legal claims. A culture comf is really a clash of cultures, and the court is not supposed to get involved in those clashes of cultures, especially when the people are deciding how to govern themselves best through their own laws. So he says here, in holding that homosexuality cannot be singled out for disfavorable treatment, the court contradicts a decision, unchallenged here, pronounced only 10 years ago in Bowers versus Hardwick, and places the prestige of this institution behind the proposition that opposition to homosexuality is as reprehensible as racial or religious bias. Whether it is or not is precisely the cultural debate that gave rise to the Colorado Constitutional Amendment and to the preferential laws against which the amendment was directed. Okay, so basically Scalia is saying Colorado ought to be able to work this out. The court shouldn't be getting involved. You'll notice then that, of course, later the court overturns Bowers in Lawrence versus Texas. The next step actually is not to pass laws like this that ban homosexuals from accessing governmental agencies and branches of government. That's not really the process that you go about it. People in government sat down and scratched their head a little bit and said, "Now, wait a second, how can we achieve this goal without putting this blanket disability on gays?" Well, we actually moved to protect the people who have religious objections to homosexuality, and so that's why we're seeing now lately a whole set of laws coming up that protect individuals who have religious objections to homosexuality from attack, or from legal attack, rather than achieving that aim by placing bans on homosexuals receiving preferences or being able to claim discrimination. All right, we talked about San Antonio ISD versus Rodriguez quite a bit. We know that the question there is that the Texas system of financing public education violates the Equal Protection Clause, or does it? And the court said no, 5-4 vote. But really what we have here is both an equal protection claim and a due process claim. The court says that the Texas financing scheme doesn't violate the Equal Protection Clause because it doesn't discriminate against the fundamental class. It also doesn't violate the due process clause because it doesn't infringe on a fundamental right. So in this case, the court says, well, there is no suspect classification and there is no fundamental right at stake. Now, the court could have said, well, we're going to treat socioeconomic classifications using heightened scrutiny, but they didn't even go that direction. They said, we're going to simply apply rational basis to this decision. The burden is on Rodriguez. I'm sorry, I think I called him Garcia earlier. I'm sorry, I was thinking of Garcia versus San Antonio Metro Transit Authority, which is another San Antonio case. But in this case, Rodriguez bears the burden to demonstrate that there is no rational relationship between the policy and a legitimate governmental goal, and the court just simply can't find it. It says it is rational for Texas to fund their educational system using a scheme involving property taxes that seems to be rationally related. Well, Texas moved later through its own court to implement a different funding scheme, and other states have done so too. So what Rodriguez hoped to accomplish through this case was actually done at the state level. The states may go beyond what the Equal Protection Clause requires, but they can't fall beneath it. In this case, the court set the bar very low, and states have actually gone above it to say that funding schemes like based on property values violate the state's own equal protection laws. United States versus Windsor. This is a case about a very complicated case about same-sex marriages and whether the federal government has the power to deny certain federal benefits to same-sex couples who've gotten married in states that grant licenses. And the court said, no, the federal government does not have the power to deny federal benefits to same-sex couples who've been married in states that recognize same-sex marriage. And Kennedy writes here that DOMA, which is the federal statute that's being challenged, the Defense of Marriage Act, is actually injuring the very class that New York seeks to protect in this case, and by doing so it violates basic due process and equal protection principles applicable to the federal government. So Congress can pass laws designed to fit its own conceptions of sound national policy. In other words, it can define what the circumstances are for people to get benefits and things like that, but it can't deny due process protected by the Fifth Amendment, and in this case it was attempting to do so because marriage is a fundamental right, and when states recognize it, the federal government has to be willing to do so too. Grutter v. Bollinger was a case involving affirmative action. In this case, the court was asked whether the law school's admission policy, an admission policy that took into account the race of applicants only at the very tail end of the admissions process, violated the Equal Protection Clause. And the court said no. O'Connor states that this is a race-based admissions policy, that racial policies will be presumed unconstitutional, and that the state, in this case the University of Michigan, had to advance a compelling interest for the law school's admissions policy to stand up. And the court says diversity is a compelling state interest, provided the race is only one factor used to achieve the goal of obtaining a diverse class. And it says that the law school program in this case uses factors other than race to achieve diversity, but it also only considers race at the tail end of an admissions process. So, like for example, let's say that the law school has 15 seats remaining to fill. It's issued invitations for admission to as many students as it can based on their LSAT score and their GPA and their personal statement and letters, stuff like that. It's got 15 left. It's got 100 applicants who all qualify equally for those 15 seats. How does it pick? At that point, the court says, considering the race of the applicant is an appropriate thing to do. Okay, thank you very much for your attention. This has been a lecture on the Equal Protection Clause.